All right. Well, from one civil rights violation to another potential civil rights violation, Ashli Babbitt's family and their lawyer have announced that they're going to be filing civil rights violation, wrongful death against the police officer who shot Ashli Babbitt and the Washington Police Department as a whole. It's going to be this. It is going to be the same provision of law that they're going to sue under?
No, because it's a federal officer. So you don't have the federal civil rights laws only apply to state officers. So like any claim Giuliani would have, any claim, and we'll get into it later, the Alaskan folks who got illicitly raided, and Ashli Babbitt all come under federal law, not under state law, or not under the federal civil rights law that only applies to state actors. So they would be filing a Bivens claim or a claim under the Federal Tort Claims Act. And that requires an extensive process. The Federal Tort Claims Act, you have to exhaust all your administrative remedies first to be able to sue, because then in the Federal Tort Claim Act context, you're actually suing the United States government. If you're suing the individual officers, that would be a Bivens claim. And it's called Bivens after Bivens versus 6 unnamed federal agents, a U.S. Supreme Court case that established you can bring a constitutional rights violation claim against federal officers. I mean, you used to be able to do this all the time. I mean, after our founding, you could sue anyone who violated your rights under common law tort theory, and it was a defense whether the person was doing so under the authority of the government within the constitutional limits that imposed. Our courts have butchered that over time and diverted it to where it's become just the opposite, where you have to prove as a plaintiff that they were violating civil rights and civil liberties, and often won't even let you sue. So now the key in the Babbitt case will be the same question that shows up in most of these cases, which is, would a reasonable police officer have pulled the trigger? And that will be based on all the circumstances known to a reasonable police officer at the time. It's an objective standard in that sense. So it doesn't necessarily matter what he subjectively thought for a civil claim, unlike potentially a criminal claim. It only matters would a reasonable police officer have done what he did. And in my view, and in talking to a range of law enforcement people that are experts, because I'm employing them for some other cases that I have, they don't see how that was what a reasonable police officer would do. It's fascinating to me that on the left, same people screaming defund
they don't see, or they do think it was a reasonable response.
They don't think a reasonable officer would have done that summary execution. And seeing the same people on the left who want to cheer defunding the police celebrate that summary execution tells you how politically motivated and corrupted our legal left has become. If Ben Crump was a legitimate civil rights person, he would be as bothered by that summary execution as any other case he's had. Yet he's not. He's mute on it. And so it's a sign of the corruption of the civil rights legal part of our system, particularly lawyers, but not only lawyers, in some cases judges and others, that they don't recognize that these should be treated equally, because it's the same legal standard in question. Was this a reasonable exercise of force? And how is summary execution reasonable exercise of force?
One thing I didn't understand or didn't know until I read the article, it was in, I forget the article that I read, that I based the last video on, but the officer was plainclothes, which I didn't think was the case to begin with. So that's a fact which may or may not turn out to be true.
It makes him look worse because, in other words, his ability, he can't say, hey, look, this person saw me as a police officer there in my police uniform, pointing a gun and saying something, and still was going forward. In fact, there's no evidence he saw anything, because his gun sort of comes out from behind. We don't even see him, and he just shoots. And by the way, he shoots. This is like Breonna Taylor case. He shoots while there's officers around. I mean, there's no guarantee that gun isn't going to go somewhere else. She had no weapon. We know that, but also there's nothing visual to say she had a weapon. So how is misdemeanor trespass worth summary execution? And the only excuse I've heard is, well, maybe he was afraid that she was going to kidnap someone. Kidnap who? They'd already left. So, and how is that going to happen? And why wasn't there a warning given? I mean, this is summary execution. That's what this was. So the same people that have no problem convicting Chauvin say that guy shouldn't even be charged. That's a completely contradictory position that, frankly, can only be motivated by political bias, in my view. Now, her problem is this is probably going to be in D.C. So it'll be. Well,
it's going to be in D.C. It's going to be in D.C. This is after investigators investigated to determine whether or not to bring charges, I guess, internally against the officer, and they declined. So, what weight is that going to have in terms of?
Oh, they won't have any weight. I mean, it would have weight if they brought prosecution and secured convictions, because it would establish that it was unreasonable use of force. But so it removes that option from the Babbitt family, but it doesn't have any other legal weight or evidentiary weight. So otherwise, I mean, the hard part is you'll have a jury pool in particular that is utterly unsympathetic and has been the most politicized. Like they remind me of 1950s all white Deep South juries. That's what we have in D.C. right now. And that's the most problematic aspect in terms of strategically and tactically. But they should get to a trial, because qualified immunity only protects what a reasonable officer would do under the circumstances. And they'll I'm sure have expert testimony that will say a reasonable officer would not have done a summary execution for a misdemeanor trespasser.
Qualified immunity, do we call it an affirmative defense? Is it a defense on the merits of the action, or is it a bar to suit in the first place?
Well, it's kind of both. So that if qualified immunity is there up front, you have to disprove qualified immunity effectively as a plaintiff. So it's both a burden it can be an issue for the jury, or it could be an issue at summary judgment, or it could be an issue at a motion to dismiss. They use it these days. I mean, again, this was an invented doctrine that doesn't apply through the history of our constitutional republic. It's mostly over the last 20, 30 years or so when it's become a popular defense, thanks to the U.S. Supreme Court. So they just invented another thing to excuse misconduct and malfeasance by federal politicians, in this case, law enforcement officers. And so but the way it functions is here, there's no question that there was a known constitutional right being violated. You have a right not to be shot. Sometimes that's the issue, because what they sometimes say is, yeah, we violated your rights, but the way we violated was so creative that it was totally new, and we had no notice or knowledge that would violate your rights. I mean, and you see courts come in and rush to that preposterous excuse. But that won't be an issue here. What will be an issue here is whether a reasonable officer would have done what he did, and that tends to be a fact-specific question in this context. So it's likely we'll get to discovery, and we'll likely get to trial.
It's got to be filed first, and we'll see the lawsuit if and when it's filed. But the lawyers announced it. There's
It probably won't be until October, because they got to wait 6 months to exhaust administrative remedies under the Federal Tort Claims Act.
So those were some delays mentioned in the article, where he said they're going to file a notice within 10 days. They're not going to file a suit until they've exhausted the remedy under the federal. Right. I forget the name of the act now. The federal. It
may come sooner if they say no, we're not going to honor the claim right away. But what it is they have 6 months, the feds do, to respond. And they may wait the whole 6 months. Sometimes they don't. Sometimes they do. So, but they got to wait for that before they can file the suit. Now, they might settle the case too. That's always possible. I don't anticipate it in this context, because the Justice Department concluded that no criminal prosecution would take place. The civil division will probably respond the same way, particularly given who is politically in control over those divisions right now.
Yeah. All right. Well, we'll see where it goes. It's I think this is going to be one of the ones where my opinion, initial reaction, is going to have changed. I've seen the video now, and I've having read some additional information as detailed in this article. I'll read the lawsuit when it's filed, if it's filed. But Stephen Goldstein said self-defense. She was going through a secured area. Self-defense still has to be proportionate to the risk being posed. And
of course, it's amazing. The same people are saying that Rittenhouse doesn't have self-defense when people are grabbing his gun to take it away from him, or pointing a gun at him, or trying to bash him over the head with a skateboard, are saying this was self-defense because someone was walking through a door.
But even if you explain it in a more lofty terms, she's going through a broken window that was just smashed through with somebody's helmet, and there were warnings, et cetera, et cetera. Seeing what was in the hallway, what was the imminent threat that could have justified objective, instant, deadly force, especially other circumstances.
There's officers behind her. Why aren't they physically arresting her if they saw this as a great threat? There's officers with machine guns behind her. So to say this was reasonable use of force, I could see someone that just defends cops across the board, no matter what, saying that. But almost everybody saying that is saying Chauvin should be lynched, and saying Rittenhouse doesn't have self-defense. So I was like, I don't think so. That's just politics governing your decision. If she was African-American and a Democrat, and that was a white cop, a 90% chance those same people reverse their opinion. That's the problem I have. The law is supposed to be one rule of law. And the rule is, was it for a reasonable officer to do it? And I know very few officers are willing to say that was reasonable use of force.
Yep. It's
I mean, George Floyd could have got up and drove in while under DUI and killed somebody. So then didn't Chauvin, wasn't he justified in actually deliberately trying to kill him under that logic? These people haven't thought through the consequences of what they're saying. It's because, like I said, I think it's political bias that's driving it.
No, there's no question, and the circumstances are a little easier now that everyone's described it as an insurrection. It was, they're attempting to take over Capitol Hill. So any response,
and we saw more evidence that didn't happen at all. Turned out even bear spray wasn't even used. That turned out to be another lie. Not only did they not kill the officer, they didn't kill or harm anyone. Turned out nobody had weapons. Apparently, turned out the person that had the tie things turned out not to be what they claimed they were. So, I mean, all of their case keeps falling apart. All this, this was a riot, and that's what it was. And you had some minor crimes related to it. But the idea that anybody's life was an imminent risk doesn't make sense. And from what I have seen, there's no evidence that officer or the officers next to him gave her any warning at all. There's no, hey, if you move another step forward, I'm going to shoot you right here. There's nothing like that I've heard.